Many are calling it very progressive, quota within quota. Interesting also to note what the 4 judges said when they spoke of excluding the creamy layer. What legal implications do you make that this judgment would have?
I think the primary legal implication of this judgment will be that states will now, that the determination of scheduled caste, scheduled tribes was and still is exclusively with the central government. But within the scheduled caste groups and scheduled caste tribe groups, states will have the liberty now to give a certain amount of quota specifically for groups within those groups which have not benefited from reservation. So effectively, it's really taking the reservation logic forward that you have to benefit the weakest amongst even those groups. Up till now, the earlier judgment, which was overruled today by majority, said that scheduled caste is a monolith. Once the president, on the aid and advice of the central government, notifies it, states don't have any liberty to sort of tinker with it in any manner and change or create sub-quotas. That changes today. And therefore, states will, my assessment is that states where there are large scheduled caste and scheduled tribe populations are likely to carry out certain fact-finding exercises to determine which are the castes which within the scheduled caste and scheduled tribes which haven't benefited as much from the reservation, and then possibly give some kind of preferential quotas for them within the existing quotas for scheduled caste and scheduled tribes. There are already 2 or 3 states which had done that, Punjab, Andhra Pradesh, etc. Those legislations actually have not been tested. Yes. Yeah, those legislations, because this is a 7-judge bench, this was just testing the earlier judgment of the court of 5 judges, and they said that judgment was incorrect. Now, based on the new finding of law as per the 7 judges, those legislations of the 2 or 3 states, Punjab included, will be tested by the Supreme Court in due course of time. But I think the bigger picture really is now it's open to the states, and I do see a whole bunch of states carrying out that exercise and going ahead with it. The second implication of this judgment is creamy layer within scheduled caste. Now that is a slightly different concept, but there was already a judgment of Supreme Court called Jarnail Singh, about 4 or 5 years old, where it was held that even in the context of scheduled caste and scheduled tribes, you can have creamy layer. There are 2 views on it, whether you should have scheduled in scheduled caste and scheduled tribes, should you have creamy layer or not. My personal view, if you were to ask me, I don't think it's required, to be honest. But that's debatable. I mean, and the court has taken a view. Now, this is the second judgment in which the majority of the court has said that, listen, even in scheduled caste, scheduled tribes, you should have creamy layer. And I think going forward, that possibly is going to be the position. The challenge, however, will be, will states actually notify scheduled caste creamy layer? Because even after the earlier judgment in Jarnail Singh, states were reluctant. And I doubt very much that even now states will do it, because I think it doesn't suit them. And that also is understandable at some level as far as I see it. So, I mean, I think it's a major rejig of the quota system, and as simply said, quotas within quotas are now something which is permitted.
But, you know, Shadhan Farasat, what's really interesting in all of this is, on what you touched of the second part of your submission, is when 4 judges spoke of excluding the creamy layer. Now, that walks the thin line between social justice and economic justice, and also highly controversial and very, very debatable.
Yes, it is. It is a little more controversial than the issue of quotas within quotas, for the reason that if we look around us, even today, you will not find many scheduled caste and scheduled tribes, even from the relatively better off groups within them, in either jobs of public sector or private sector. So even if there are some who are financially better off, but are there, they play a representational role for those scheduled caste and scheduled tribes. So that's why my personal view has always been that time has not yet come for having a creamy layer within scheduled caste and scheduled tribes, because even the better off groups within them are still not sufficiently represented. That's why I think the majority, one of the judgments of the Chief Justice is silent on this aspect. The Chief Justice's judgment does not pronounce on the creamy layer, but like you said, 4 judges have come out in support. And in fact, as far as the law is concerned, the law was clear 4 years back that creamy layer in scheduled caste and scheduled tribes is permitted. States have still not implemented it, and my personal instinct is I don't think the states will implement that even going forward, even after this judgment.
Well, it's interesting because, you know, it opens up a completely different debate, and which has been hotly contended, especially in our country, where it comes down to social justice, economic justice. But Kancha Elaya, you know, 6-1 majority holding the sub-classification where SC/ST is concerned. How do you think the Dalit community is going to view this?
The judgment is very clear that within the scheduled castes and scheduled tribes, in fact, across the country, there are scheduled castes and scheduled tribe people who are saying that our caste group has not been getting seats and jobs and so on and so forth. And particularly the whole case came in relation to Andhra Pradesh, the Madigas and Malas. And for 4 years it was implemented based on the commission recommendation, then the Supreme Court struck down. Now the question is, the 6-1 judgment clearly gave an order that the states have right to reserve for subcastes where there is injustice to them in the seats, jobs and so on and so forth. But at the same time, the Supreme Court also made it very clear that the states have to justify, the word justify, with empirical data that there is injustice to certain subcastes within a given state. Now this underlines caste census is absolutely necessary, because even in scheduled caste, scheduled tribes, there is no each caste data based on census. Now without census, even in Andhra Pradesh, Telangana, where it was earlier implemented based on a commission recommendation called Ramchandra Rao Commission, 7% was given to Madigas, that is Chamas, and 6% to Malas and subgroups within that. Now this can be challenged based on the empirical data. Now how do they calculate? So and so caste does not have enough representation in jobs, in seats and in the center. How does the center deal with this? Without caste census. Supreme Court, without stating, it underlined evidence with empirical data means only caste census now. That is one point is very clear. The second issue is, I don't think it is an order now. 6 judges on one side, 1 judge on one side, the judgment pronounced by Chief Justice is the main. Certainly, the opinions of judges on the creamy layer cannot be taken as a judgment by the state.